All right, this is cause number 1830854. And sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel. And before we get into a whole lot, I've done a lot of my own research and looking at all of this. And a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think
Wow. Right from the start, the judge is already signaling frustration. You can feel she's tired of lawyers misusing procedural tools. And honestly, she's right. A subpoena ducis tecum is not a fishing expedition. The judge is basically telling the defense, I'm not denying you the info, I'm denying the method. This sets the stage for a whole hearing about tone, respect, and process rather than just evidence.
this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations.
This is where the tension really starts to build. The DA is saying, why are you subpoenaing the entire probation file when none of this is even part of the allegation? And the judge isn't denying that. She's trying to keep the process clean. You can feel the courtroom getting defensive on both sides. Classic legal turf war.
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
This argument from the defense is actually legitimate. He wants to show his client's performance on probation, payments, attendance, compliance, because it can absolutely influence whether the judge revokes probation. It's a smart strategy, but the delivery, that's where the cracks are starting to show.
Again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try.
This is such a judge moment. You get more with honey than otherwise. In other words, stop coming in like a bulldozer. This judge wants cooperation, not combat. It's a rare, candid reminder that courtroom wins often come from diplomacy, not dominance.
Ms. Juan, or do you have any concerns you want to
If there's
make the court aware of?
Your Honor, just with the clarification of our departmental chronologicals, which include anything that pertains to the case that happens with chrono telephone calls, auto-generated appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena. as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed with the exception of the offense report.
The probation officer's list is wild. Chronological logs, phone calls, drug tests, auto-generated reminders. Probation tracks everything. And this is why the judge is so strict about process. If that file is mishandled, it's a privacy nightmare. This moment educates the viewer on just how much personal data probation department hold.
You seem very frustrated, and I'm not sure why. I don't know.
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
that is alarming to me that we would
Fire, this is the peak of the drama. The judge flat out calls the lawyer out. I'm agreeing with you, and you're still arguing. That line alone should be in the thumbnail. This is where the defense attorney loses the room. Judges hate unnecessary combativeness, especially when they're already ruling in your favor.
Down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Be needed?
I'm sorry? No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay? Good?
Yes, Your Honor.
All right. Thank you, y'all.
Thank you.
This closing is the judge laying down order. Everything must go through the DA's portal. Nothing directly from probation. She wants the paper trail clean and the tone civil. This whole hearing became less about evidence and more about attitude, and the judge made that crystal clear.